All right, good afternoon. If we could go on the record in the courtroom.
We're on the record.
Thank you very much. This is the Family Law Docket B for July 18th, 2023. My name is Patricia Fassett, and I am the judicial officer handling today's docket. Please make sure you're muted until your case is called. Are there any strikes, setovers, or quick matters this morning?
Your Honor, this is Ms. Poplawski on the Crystal Morrison matter. I'm going to ask that be stricken. The parties have resolved that with an agreed order.
All right. And are you here on behalf of Ms. Morrison?
Yes.
Okay. All right. And I'm assuming, do we have Christopher Morrison present? *6 to unmute on if you're on a telephone. All right. I will strike that matter, and that's for the record 20-3-00173008.
Yes, thank you, Your Honor.
Thank you.
Your Honor, number 15. I don't see Ms. Hoke here, but we understood from her that she was having that set over. I don't know if that has already happened.
I'm here, Your Honor.
Oh.
Yeah, I just, no, it hasn't, because the docket just started. So
Yeah.
We're asking that be set over to August 1st on the 1 o'clock docket.
All right. And I'm sorry, I don't have a docket with numbers. I need to know what case you're calling, please.
Oh,
Sure.
sorry. DeDios and DeDios.
Okay. So 23-3-00-4308.
Yes.
That's right.
And August 1st at 1 p.m.
Yes, please.
All right. And yes, Mr. Reed, are you representing the respondent at this point?
I am, Your Honor. I believe we've filed a notice of appearance already in this case. I'll make sure that that's happened.
All right. We will set that matter to August 1 at 1 p.m.
Thank you, Your Honor.
Your Honor.
Thank you.
Appreciate it. Yes.
Right. Any other strikes or setovers?
I have a set over, but Ms. Beagles doesn't look like she's online yet. But I do have a very short matter on number 5, Minute B and Minute B.
Okay, hold on. Sorry, one moment. All right, Menifee and Menifee is 20-3-00227008 on for order, signing of order. I didn't see, I know that there was a question from, do we have Miss Menifee present?
Yes, I'm here.
Okay, so I know there was a question last time about the start date, or the end date, excuse me, of the support, but I didn't receive any other written objections. And should I have Ms. Gilmore an order in my stack here?
You should. The only complication would potentially be is if it was destroyed after the last hearing in front of Commissioner. If not, I can present another order.
All right, I don't see one in this stack. I know that I reviewed the proposed order that was filed back at the end of June. And I reviewed the hearings, the previous hearings, and feel that that order does comply with the court's order. So I will sign off on that order once presented.
Your Honor, this is the clerk.
Sure.
We just handed you that order.
So
I don't, I put it in the stack here. I don't see Menifee. Let me double check.
Your Honor, it was paper clipped behind the other order.
So it's paper clipped to a different order.
Yes.
All right. I see it was behind another order. So I do have that, Ms. Gilmore, so I will sign off on that.
Thank you.
Right.
So Your Honor, this is Miss Menifee. So my understanding was nothing was done until we did the court date, which was on the 11th. And so I didn't have nearly enough time to be able to figure out changing my finances completely to be able to pay rent. So I'm currently back on my rent right now because I thought that I had at least that one last payment of the first before the court date of when we're supposed to actually sign and come to the agreement on this.
Well, I think I made the ruling back in June. That that there'd be no more payments. So,
But it wasn't signed until we had the court date. And
I understand that, but it's essentially effective as of the court's ruling. So I will enter that order as proposed, hearing or not receiving any objections other than the clarification that I think we dealt with last hearing.
Thank you.
All right, thank you. All right, any other, excuse me, quick matters or strikes or setovers?
I have a quick matter, I believe, Your Honor. Actually, I got two.
All right,
The first one is St. Peter and Brooks, number 10. That's just on for a GAL review. And the parties received Ms. Height's report last week. So I think that matter can be stricken for today's purposes.
all right.
I agree with that, Your Honor.
All right, so that's 21-300-25708 St. Peter and Brooks. Thank you, Ms. Height, for getting that report in and can be noted back up if there's any requests, if there's no agreements.
We'll do it. Thank you.
Thank you.
And then number 17, Spalenka is on for a presentation. We sent our proposed orders out. It looks on July 3rd and have received no contact from the respondent on that. So I'm just asking you enter the orders as presented. I think they accurately reflect your ruling from a couple of weeks ago. And I did not see that we got any formal objections to those either.
All right, do we have Ms. Spalenka present?
I did not see her on the roster.
I do not see her. I did review the orders and along with my rulings from the previous hearing, there are no objections that were made. So I will sign, I have those orders here. I will sign off on those orders. We do have an interpreter matter, and I'm not sure if there are any attorneys associated with that interpreter matter. But if we could call that next.
Yes, good afternoon, Your Honor. Ivan Gerardo, Western Court Certified Spanish interpreter. I'm here for the Guzman Garcia case.
Thank you very much. All right. And for the record, this is 20-3-0034508.
Y para que conste en actas, este es 003408.
And this is a motion for temporary order.
Esta es una moción para una orden provisional.
And is Guadalupe Perez Garcia present?
Guadalupe Pérez García se encuentra presente.
*6 to unmute on a telephone.
Si está por teléfono, abra su micrófono, presione *6, estrella 6, por favor.
All right. So I have the temporary orders that have been presented. I do want to clarify something, if possible.
I'm sorry, Your Honor, is she present? Is Guadalupe present?
No, but Modesta Paz Guzman, I believe, is present.
Okay.
And so if I could just clarify from Modesta about one of the orders presented.
Y si puedo aclarar de una de los escritos que se presentó. La pregunta es para Modesta.
I have two different child support or temporary child support orders.
Porque tengo dos diferentes órdenes de pensión alimenticia.
And it appears as though one of them is typed and one of them is handwritten.
Parece que uno fue escrita a mano y la otra fue escrita en la computadora.
Otherwise, in my quick review, they look to be identical.
Pero así nomás al repasarlas, así parece que son idénticas.
Was there, is there any difference between the two temporary child support orders that you presented?
Esas dos diferentes órdenes que presentó de pensión alimenticia provisional, ¿hay alguna diferencia entre las dos?
No.
No.
All right, so one of them is dated 6/23. Let me double check that.
Una tiene la fecha del 23 de junio, pero permítame,
6/23/23.
23 de junio de 2023.
So I'm gonna enter that order.
Esa es la orden que se va a presentar.
Okay. Along with the temporary family law order.
Y también la orden provisional de la ley familiar.
And I have two parenting plans that both state that they're amended. Is there a difference between those two plans?
Tengo también dos diferentes planes de crianza y parece que se les hizo cambios. ¿Hay alguna diferencia entre ambos?
No recuerdo.
I don't remember.
Okay. Give me 1 minute. All right, it does look like those are identical, so I'll sign one of those.
Parece que son idénticos. Voy a firmar uno de ellos.
Okay. And then I also have the child support worksheet,
Tenemos aquí todos la calculación de la pensión alimenticia.
which I will sign off on as well. So I've entered those, all those temporary orders. And you should be able to get a copy of those later this week from the clerk's office.
Ya los firmé. Después esta semana, si gusta pasar aquí por la corte, puede recibir copias de estos documentos.
Okay.
Okay.
All right, thank you very much.
Muchas gracias. And thank you, Your Honor.
Thank you, Mr. Gerardo.
Es todo.
Your Honor, this is Megan Gilmore again. I'm appearing on the Langley and Langley matter. I just got confirmation from Ms. Beeples. I thought she would appear as it was her motion, but she has given me written confirmation that I can set that matter over at least 2 weeks based on the court's availability. Hi, Ms. Beeples.
I'm finally on. I have no idea. It did not want to let me on, but I am here. And no problem setting that over.
Okay, and so this is the, I'm sorry, the Barenberg Langley matter?
Yes, Your Honor. We're
Okay,
trying to
let's-
settle this.
All right, so that's 18-300510008. And I believe, unless the clerk tells me otherwise, 2 weeks out, August 1st, there's availability. August 8th should have availability. So
Let's put the 8th just to be sure. Is that fine with you, Ms. Beeples?
We can set the 8th. Yeah.
okay, so we'll set the all right, Barenberg Langley over to August 8th, 2023 at 1:00 p.m.
And as long as the restraining order is still in effect, I believe Ms. Gilmore and I already agreed to that. I can do an order continuing that.
That's no problem.
Okay.
An order extending it.
Yes. I'll have that directed to the court after Ms. Gilmore reviews.
Perfect. I will sign that once I receive it.
Thank you.
All right, thank you. Hold on, my computer froze here. Or Odyssey froze. Okay, I think I have it back. All right, any other quick matters, strikes or setovers?
I think number 13, wrap and wrap will be quick, Judge. That's a review of the spousal support payments made by Mr. Rapp.
Yes, 22-300400508. Believe I directed, is Mr. Rapp present?
Yes, Your Honor.
Thank you, sir. I think when we were last here, needed to get everything to Mr. Zandy's office. By like, I think the 13th or something of June. Where are we at?
The case that we discussed, this was set for a mandatory settlement conference on June 29th. And then about 2 days prior to that, we were informed that the matter would be stricken due to a lack of a judicial officer at that time. So unfortunately, we were not able to go forward on that. Although we did file our trial aid and we have, I'm not certain offhand if we've set another date for that. I believe we have. So that will be forthcoming. I can say that Mr. Rapp did provide some of the information requested and ordered by Commissioner Nelson last spring. Not really overly concerned with that. I just am more concerned with the fact that since we were last in court, we've received one payment and that was in the amount of $500, and that came in through my office yesterday. So Mr. Rapp continues to go backwards in his support payment. And that amount that's now past due continues to increase every month. And my client desperately needs that maintenance money. So we're in largely the same position we have been since last fall. That outside of that debt on Mr. Rapp's side of the ledger continues to surmount.
It does not appear, but please correct me if I'm wrong. Has there been a rescheduling of that MSC?
I would have to grab my calendar. I've reset several over the last couple of weeks. I thought we did, but we might not have. I might have just got the notice out to set it, which might be next week.
I have September 7th, so you do.
Oh, there you go.
Okay.
September 7th.
All right. Well, Mr. Rapp, I can't, this is just a review hearing. I can't stress to you the importance of getting those payments made as timely as possible. I understand the inability to pay, but the hole that you're digging is getting deeper by the day. So as much as you can, as much you can pay on those, the better. Any need for another review, Mr. Zandy, or you want to just leave it on for the MSC on the 7th?
Let's leave
Your
it
Honor?
on for the MSC on the 7th, and then maybe we could set a review after that, maybe the end of September, if we can't resolve the case on the 7th. I do like to have that backup date, just in case because my client desperately needs it. So I think that probably makes the most amount of sense given the circumstances.
All right. And Mr. Rapp, did you want to say something?
Yes, yeah, I'm working today and I'm starting to pick up a little more work. J.H. Kelly called me, so I'll be able to pay some more.
I'm very glad to hear that.
Yeah, I'm retired, so I don't work every day.
All right.
I'm
That's
doing the
good
best I
news.
can.
That's good news. Mr. Zandy, do you want to set a review on the docket today?
Yes, if we could for late September, I think would be ideal.
How about September 26th at 1 p.m.?
And I will be out that day, but I will ask my associate if she would be willing to. Are you okay with that?
That's fine.
Yeah, that'll work.
Okay. All right. So, Mr. Rapp, your next date is September 7th for that mandatory settlement conference. And then we set a review for the 26th of September at 1 p.m. If you resolve that case, that can be stricken and you wouldn't need to appear, but that'll just be a backup date at this point, should you not resolve. Right?
Okay.
Thank you, Your Honor.
Thank you.
Thank you. Bye.
Bye. All right. Let's just start at the top. Amnot and Martina Schroeder, 20-3-00357008.
Matter's ready.
And we have Mr. Martinez present. Okay.
Present.
So this is good morning or good afternoon. Oof, it's been a day. On for a motion for adequate cause. And I've reviewed everything that's been submitted thus far. I will say that I did also review the orders that were entered in May of 2022 that included essentially a year from now that expanded visitation could be addressed to include some summer, I think it said summer visitation. So, however, there was a motion for adequate cause filed. So, Mr. Martinez, this is your motion. Any additional information you would like the court to know?
Yeah, I submitted more evidence saying that I have been sober for over 2 years. I'm caught up on child support. I have met every demand from the court. And yeah, I just want to say that the time that I have now is not adequate enough time to be a father. So I just like to put that in there.
Okay. Thank you, Mr. Zandy.
And thank you, Your Honor. The court's aware I do represent the original petitioner, non-moving party to the motion before you today. And I think you're correct initially on your analysis of why we're here. There is a built-in provision in that May 2022 parenting plan that allows either party to come back and kind of look at the plan to tweak it. Specifically noted is the summer schedule commencing in 2023 forward. And then just to kind of some housekeeping issues as they may come forward. There was specifically by design, nothing related to a petition to modify that parenting plan. And that's due in large part based on the intent of the parties at the time to just kind of tweak it and see where things were after that 4-phase built-in schedule. So I would say, from a procedural standpoint, I don't believe the petition has the legal merits to proceed on that. Anytime you're asking the court to modify a parenting plan, you're alleging a substantial change in circumstance to the child or the non-moving party. We don't have that. It also, depending on the request, could open for wholesale changes to that plan or significant variations from the existing parenting schedule. I don't think that's properly before the court. So I'm asking the court to, number one, deny the petition and dismiss that petition on a formal modification. Now, moving forward, and again, based on what the parenting plan does permit, which is the review, I'm assuming that's kind of why we're here. And again, I don't want to get caught up in the technicalities of everything, other than to say that that plan relates to the summer schedules exclusively almost. And then again, as I mentioned earlier, any tweaking of any provisions related to the 191 factors that are currently in place. This is a situation in which we just went through a very in-depth GAL investigation from Mr. Lawrence. It's a case where Mr. Lawrence found less than 2 years ago some very troubling history of Mr. Martinez, including substance abuse, including abusive use of conflict, and including some of these actions which can only be described as immature. We'll mention for you that part of those findings and part of the 191 findings and factors that went into the existing plan were based on a repeat lifelong history from Mr. Martinez. It's a case in which he has been to treatment at least by our count 6 different times. That's in treatment, that's outpatient treatment. That is through church sponsored treatment programs. And all of these have very minimal effect. In review, and I've been involved in this case since the onset. In review of his most recent declaration, this is largely the same thing we have heard from the very beginning, dated back a couple of years now, related to I'm sober, I've made life changes, I'm on the straight and narrow, and all is good. If you did have the opportunity to go back to the information and the report provided by Mr. Lawrence, you would see that again, some of the credibility of Mr. Martinez has been called into direct question related to those comments. We have those same concerns today. In fact, he breaks up with a girlfriend and she says, not only was he drinking, he was drinking quite a bit. Mr. Lawrence found that to be credible and true. And this was during the same time he was talking about his sobriety and how he had turned the corner and taken it seriously. The fact that he's been to treatment on at least a half a dozen separate occasions, again, and at the end of that, the same routine. I'm clean, I'm sober, nothing's going to happen. That has not held any water and has not progressed to a point of calling that permanent by any stretch of the imagination. If at all, his sobriety is usually very short term and in brief intervals of time. We move forward and look at the impact now on 6-year-old Caden. Now, this is a child who is doing well. This is a child who loves his father. There's absolutely no dispute related to that. My client details for you that she would like Caden to have more time with his dad. But what's happened over the course of the past year, again, gives a lot of those questions that we had dating back several years now, brings those directly back into light. It's our understanding that although Mr. Martinez complains about the lack of time he has with his child, he spends what time he does have taking him to AA meetings. There's been this return of the child in which he is essentially glorifying the fact that daddy is an alcoholic. He almost thinks it's comes with a badge of honor. We've given you several instances of concern where dad's in AA meetings, child is in the back, presumably playing with other adults or whoever else brings their children to those AA meetings in an atmosphere that my client is certainly not comfortable with. We also have dad giving his child his coin. And again, there's no issue with that per se. The problem is when the child asks my client upon return and her husband, Caden's new stepfather, if they drink alcohol. They say no. And Caden's response is, well, I want to be like dad. I'm going to drink all the alcohol I can so I can get more points. Again, completely missing the fact of what this all entails. And again, this is a 6-year-old child. We wouldn't expect him to be mature enough to understand the impact of this or what it all means. That's problematic. Mr. Martinez has, and he denies it. And my client details for you that there's been instances where he's, for laughs, had the child blow into his blow and go device on his vehicle. Again, setting a very unusual standard for Caden to try to figure out what this is and how this plays in and how this is part of his dad's history. But again, that's problematic. And then lastly, and again, Mr. Martinez disputes it. My client saw it. She puts it in her declaration that Caden has even returned from visits with, apparently there's an attachment on the blow and go device that comes off every couple of months. Caden had that in his backpack and again was parading around with that as though that's some kind of a badge of honor. That's problematic. We move forward and we've got these communication issues. And I would say this has again been an ongoing issue since prior to the final parenting plan even being entered, in which Mr. Martinez appeals to his child by asking him to have my client give him money, tells the child in no uncertain terms that I can't afford that because your mom takes all my money and therefore I've got to work more longer hours. Child gets caught in the middle of that and literally goes to my client not once, but it's not unusual for him on multiple occasions to ask my client for money so he can buy, I believe it's Pokemon cards and bread and groceries and sweatshirts and the like because his dad doesn't have any money. Also returns and asks my client why it is that his dad only gets weekends because dad's attributed that to my client, and says, well, that doesn't seem fair, which is information that's coming again directly from Mr. Martinez. That's very problematic. So my client tells you that for concerns about not only the substance abuse, but some of these maturity issues, that's a perfect example of that. And it frankly needs to stop. Mr. Martinez needs to enjoy his time with his child. Cade needs to enjoy his time with his dad. And they need to just have off base and not discuss these adult matters related to child support, to parenting plans, to residential time and the like, because again, that's not suitable for a 6-year-old's level of emotions and mentality, not appropriate. We move forward. My client details you significant concerns about these red dye issues. We have provided you information from the doctor that says Caden should not be ingesting anything with red dye. My client details for you Caden's approach and how he responds after consuming red dye products. He is extremely agitated. He is hyper. He has a hard time following directions. And again, we have a child who reports, my dad doesn't believe in that, so therefore I eat whatever I want to at my dad's. Again, sign of an issue and maturity problems. The living arrangements, I'm not going to get involved in that. My client details it for you pretty specifically. Mr. Martinez doesn't really dispute any of that, other than for me to say dad lives in Vancouver, child is local. Now, there's been issues with getting the child to games. This is an active little boy. This is a little boy who loves sports and extracurricular activities. And dad's general approach is, well, it's not convenient for me. It eats into my time. Therefore, you're not going to go.
Objection.
I'm sorry.
That's a objection. Sorry, I'll let you finish. Sorry.
Okay, go ahead,
So we
Mr.
have this Jiffy Lube situation in which there was a planned issue 3 weeks before opening ceremonies for baseball, in which Mr. Martinez alleges to have made an appointment for his vehicle. Come to find out, that was a Les Schwab or Jiffy Lube situation, and he decides to take his car there as opposed to take Caden to opening ceremonies for baseball, something the child was excited over under the guise of, well, it's not convenient for me, it eats into my time. What Mr. Martinez needs to realize is that Caden's involvement in extracurricular activities is just as much of parenting time as meal time and bedtime and taking your child to the doctor. Kids love that. They gain confidence through those types of activities. Child should be allowed to go, not based on it's inconvenient for dad because he lives in Vancouver and doesn't want to go to Longview or Toledo or the like. We have these issues. Again, these have been something that have been prominent since the onset of this case. My client, rightfully so, has very little confidence that Mr. Martinez's sobriety level is going to maintain over time, given his history. And the history is extensive. There's been criminal charges from this. Now, there's been issues related to credibility that have been raised throughout. And at this point in time, we don't think there is any legal mechanism to proceed any further and grant any wholesale changes to the plan, any additional overnights or the such, because I think under the terms of that parenting plan, we are guided by that summer scheduled visitation, whether we increase that or not, and any tweaks to the parenting plan as necessary. The court is going to tweak that. We would ask for provisions about taking the kid to extracurricular activities, ask for some direction to follow doctor's directives related to the red dye situation and any allergies, and have a provision in there that the child has his own bed when staying at dad's residence, as the child is now, will be 7 here shortly and is still sleeping in the same bed as our understanding as dad. We have questions about that. Now, so again, if we are going to tweak that as detailed or prescribed by the existing parenting plan, we think that is the best method to proceed in. And if the court wants more information about the summer schedule, it might help to get a limited review from Mr. Lawrence to see if that's appropriate, to see where Mr. Martinez is in his treatment. Although he states he's provided information about the evaluations and about the treatment and the sobriety, we really received very little by means of that. The court is going to advance and consider any additional time for the summer of 2023, or probably more appropriately, since it's already half over, 2024, perhaps getting a quick look from Mr. Lawrence on that limited issue pursuant to the parenting plan would be the best cause of action.
Clarification. So Mr. Martinez has already gone through all 4 steps and is at weekends, Friday to Sunday, correct?
That is correct. Yes.
Okay.
Your Honor, I'd just like to say real quick, at the bottom there in the asterisk, it says, at the expiration of 1 year, either party may motion the court to review on the regular domestic docket. Just want to point that out.
I did see that, Mr. Martinez. What you filed is essentially it's a motion for adequate cause. Adequate cause is under statute 2609-260, and basically it requires the court to make a finding that there's a substantial change in circumstances with the child or the non-moving party, so not you. Okay. I can't make that finding. Your accomplishments seem to be massive. I mean, 2 years of sobriety is a huge thing. And I applaud you getting to that point. I don't disagree with your position, feeling like you don't have enough time. I'm sure a lot of parents feel that way in circumstances that are similar to yours. I also wanted, so I can't make a finding of adequate cause. I am, however, willing to consider the summer visitation based on where we're at. It appears as though there's been really no issues that have been raised by either party up until this motion for adequate cause. So we're in the final stage of the parenting plan, which authorizes a full weekend, Friday to Sunday, with dad. And I apologize, I moved on. I don't know how, is that every other week?
Yes, every other week.
The other question that I had, Mr. Zandy, I'm directing this to you. There was in something that was filed by Mr. I believe it was filed by Mr. Martinez. Your client indicated that he wasn't allowed to be at any of the sporting functions when it wasn't his parenting time. I don't see anything of that nature in the parenting plan. Would you, I guess, agree that there's nothing that prohibits Mr. Martinez from appearing at games or practices when it's not his time?
Or school events?
I would agree to that, and I would encourage him to do that, because I think that's something that both parents should be actively engaged in, and I think that's to the benefit of the child. So I saw that too. I'll talk to my client about that. That was probably just some confusion between the phases and where we were under a temporary order that carried over into a final effect. But no, I completely agree with your analysis on that.
Okay. So I know we don't, and I think school is a month and a half from starting back up again, approximately. And I don't know what the plans are for anyone moving forward, but here's what I'm going to do. First, I want to just let you know, Mr. Martinez, that there's nothing prohibiting you from attending any of your child's sporting events, regardless of when those dates occur. So if Ms. Amnott makes a comment that you're not allowed to be here, it's not accurate. So if you want to attend any games, doesn't matter if it's your weekend or not, you are free to do that. You're free to go to practices. Hopefully all of those schedules, sounds like your child's pretty active with different sports. All those should be shared with you. You are free to go to all of those as you're able, and I encourage you to do that. as for summer, what
Sorry, real quick, sorry to cut you off. Does that also include school events too? Because I haven't been invited to any school events.
I don't see a reason why it wouldn't include school
I think
events.
I think part of the confusion on that might have been because they're initially at the onset of this, there could have been, and I'm going back several years now, there might have been some restraining orders or protection orders in place. I don't believe those are still in any existence. I'll confirm that with my client. No, if those are no longer in existence, I don't think there's any restraints from communicating with schools and participating in extracurriculars. I think that should probably be encouraged because Caden would probably like to have both parents there.
Yeah, so if there's, a school play or a rehearsal or any functions or, I would encourage you to go there. I don't see anything in my purview of your case prohibiting you from doing that at this point. So,
Thank you.
yes. As for summer, I appreciate the thought of getting Mr. Lawrence involved again in this case and having a quick review. But frankly, we have a parent that, in my opinion, has shown that there's been some consistency with sobriety. There's been no issues raised by Ms. Amnott. We're on the final stage of this parenting plan. So I think the summer schedule should be addressed. And so what I would like to do is for 2023, I'm going to allow dad to have 1 week. You're going to of 1 full week, so 7 days of vacation with the child to be agreed upon by both parties, the dates. And then assuming no other issues, 2024, moving forward, I'm going to authorize 2 weeks of vacation. And I think those should be non-consecutive. So two separate 1 week terms of vacation over the summer. And in 2024, moving forward, May 15th of each year, those dates need to be outlined or provided to the other party. So plans can be made on both sides and hopefully no toes stepped on as far as getting those, scheduling any vacations or flights or anything like that.
Okay.
And do you want me to draft that order? What I would like to do, so we're not doing a whole new parenting plan, is just a supplemental order to that parenting plan, take out the review language that's included and replace it on the summer visits 2023 and 2024 moving forward. I think that probably simplifies it. Or do you want a new parenting plan with those changes in it?
I think a supplemental will work perfectly fine.
And you want me to draft that?
Yes, please, Mr. Zandy, that would be perfect. We can set it. Do you think you can, do we want a presentation date, or do you think you can work with Mr. Martinez on that?
I think I can work with Mr. Martinez on that, but let's just, in an abundance of caution, maybe set a presentation date for 2 weeks out in case there is any confusion on that. And then Mr. Martinez, I'll email you a copy of that if that's agreeable to you.
Yes.
So I am going to enter the order that Mr. Martinez presented, denying the finding of adequate cause, but we'll get an order entered amending the parenting plan. I encourage you, Mr. Martinez, to start working with Ms. Amnott as soon as possible to get your week scheduled. So because we are running out of time for this summer. And Mr. Zandy, do you want that on a Tuesday or a Friday?
A Tuesday?
Is the first work?
That's fine by me.
Does that work for you, Mr. Martinez?
Say that again. I'm sorry. Tuesday is what?
Tuesday, August 1st for presentation. That's if you guys agree on the order and you sign off on the order, we can strike that date. You don't need to appear, but if there's some clarification or concern you have with the proposed order, we would appear on the 1st to discuss it.
Okay. That
All right.
works for me.
And Mr. Martinez, if you would just email me with that might expedite things for 2023. Email me with what your proposed 7-day period is. And you want that to attach to a weekend he already has, I'm assuming?
I'm not going to require that, but if that's how it works
Okay.
out this year, that's fine.
Sure.
Your
Just
Honor.
email me with what your proposed dates are.
Okay, Your Honor, I have a couple other questions, if I can get
Sure.
verification on some. So my family does live in Idaho. Am I allowed to visit my family in Idaho with that week vacation?
I mean, I don't think there's anything prohibiting that. I would assume that if that's what you're wanting to propose, I would get notice to Ms. Amnott as quickly as possible. It sounds like Mr. Zandy is willing to work with you on that. So, but I don't
Maybe
have,
just with an itinerary if you fly, or where you're going to be with a phone,
Yeah, I'll
telephone
provide
number
that.
we could reach.
I'll provide the address and everything. I just wanted verification because I know this is going to be an issue if I just spring it on her. Also, how would I go about the means of changing holidays? Because I'm very limited on the holidays that I have. Would I have to do a different application or process to do that?
so unfortunately, I can't give you legal advice from the bench.
Gotcha. Okay.
We do have legal aid or volunteer attorneys that are present in the courthouse Mondays from noon to 1 on the second floor that you can try to speak with about that. And frankly, it sounds like that may be something you speak with Mr. Zandy about. If there's an agreement about changing or switching around some dates, that may be something that you could just work out with Mr. Zandy, since we are amending or supplementing the parenting plan already.
Okay, perfect. Thank you very much, Your Honor.
All right, good luck,
Thank
everyone.
you.
Thank you.
All right, Shorenborn and Shorenborn 20-3-00205008.
The matter's ready. If the court will call and see if we have Mr. Schoenborn.
Yep, I'm here.
All right, thank you, sir. All right, we are reviewing child support. I did receive, sorry, my Odyssey is super lethargic today. That's what I'll say. So it's taking me a little while. I did receive, Ms. Baldwin, your most recent filing, the debt calculation from a couple days ago. So I have that. Mr. Shorenborn, do you have good news about employment?
Yes, I think so. So I got an official offer. We agreed. I signed it. That was about 2 weeks ago. I went in, did my physical and my background check, and they said it'd be about 3 days on my background check, and it's been about a week. And I talked to HR on Friday, and they said they'd give me a call midweek this week to discuss. And so I have no idea what that means, but yeah, so I don't know. I don't think I have anything in my background that would raise any red flags. All that's supposed to be like cleared out and done with. So, but yeah, that's all I'm waiting on right now is for a call back from HR.
Okay. Fingers crossed. Ms. Baldwin.
Thank you. Respectfully, I'm skeptical. The court should be too. In this case, we have arrears more than $18,000. That doesn't include the arrearage on the medical support that the court's already ordered another $5,600 in arrearages there. Payments are lacking, as indicated by this debt calculation showing that he's continuing to go up in payments that are obligated. He's filed nothing. Previously, when we reviewed this case, he filed nothing but self-serving. Look, gee, here's a couple things I'm saying I'm doing, but not a shred of evidence that supports it. Where we stand today is the identical position, except he hasn't even bothered to file anything. So again, we're in a position where he's not making payments. He's not paying down the arrears. And he's blown off the last court hearing, causing additional fees to my client. And it's just, oh, I swear this is happening. It's in the works. This is the same thing we heard from him last time. And again, the concern here is last we were aware of Mr. Schoenborn is not clean and sober. And so the problem is if he's going in and having a physical from HR, it's hard to believe he's going to pass it, knowing that he's not clean and sober, or at least isn't providing that to the court. The last drug test that we have from him places him positive for some very serious drugs that are certainly not legal in his possession. Given this, again, there's just nothing in the file beyond his self-serving statements. Our proposal, again, our goal here is not to throw him in jail. We want him to work. We want him to start paying. That is absolutely the goal. If he says he's gotten this offer letter, why isn't he got it 2 weeks ago? Why isn't a copy filed? We don't have anything here whatsoever. So my request would be to push it out an additional 2 weeks. For that time, the court to consider the fees for all 3 hearings. So the hearing he did not show up for, the hearing today, and the next hearing that we have, consider those fees. And if he hasn't made a substantial payment or filed anything into the court record, that he should have to appear in person if at all possible. At some point, we're kind of making the court toothless in its penalties. And Mr. Schoenborn needs to pay as ordered or provide proof, real evidence that he's actually making an effort to get employed and make payments and not just continue in his addiction. So again, that's our concern. I'd ask to put it out 2 additional weeks, order him to file those things. If there's any ability for him to appear in person, I think you should have to. The court can again consider those fees. But if he hasn't, if we're in the same position in 2 weeks, the court should order jail time. That's where we're at. This has been a long-term problem that needs to be addressed. And if jail time is what will make Mr. Schoenborn serious about the issue, then unfortunately that's where we are.
Your Honor, can I say something or ask a question?
Sure.
What proof do I need to show all my applications? And I mean, I'll send anything you guys want, but every time I make a list or say, hey, here's every place I applied for, I just get called a liar and that I'm not actually trying to do this. I could send the offer letter in. I had no idea that I needed to send an offer letter in to show that, like, I'm trying here. I did email them, and I apologize for missing. That was during one of my interviews, and honest to God, I just spaced it. I told her I will pay for that. I'll pay for her attorney fees on it. Like, I don't like her going in the hole. I also emailed and asked if we could set up a payment plan while I'm still trying to become employed on some of the medical and that kind of stuff, just as a good faith, like a couple $100 a month or something. My parents are willing to do that because they know I'm trying. They know how many interviews I went to. But yeah, so a couple of things. If I could start a payment plan until I am employed, that's willing to do that. And then the other thing is, what exactly do I need to send to prove that I have went to these interviews, that I have been putting in ample time trying to get a position that will pay for all these bills?
Okay, so I'm going to ask that you do file that offer letter and provide a copy of that to Ms. Baldwin's office. And that you do that no later than Thursday of this week, which is the 20th of July, close of business.
Can I email that to the court?
No, you need to file it with the court. So that means you have to actually get to the courthouse and file it with the clerk.
The bridge is closed till the 24th. Like,
I'm sorry, I'm not sympathetic to that at this point. We're really far down the line. As for the payment plan, if they're not responding to a payment plan, you could just simply start making payments because you were ordered to do that quite some time ago. So if you want to start paying a few $100s a week or every other week, anything helps at this point because you're doing really not much of anything. I know you've made a few substantial payments and your parents have helped you out. Just because Ms. Baldwin hasn't said, yes, let's make a scheduled payment plan, doesn't mean that you can't just start sending money. Because you are, the most recent debt calculation has you basically in the hole by, sorry, the copy that was scanned in, Ms. Baldwin doesn't, I can't read it really well. Is it?
Page 2, it's more than 8.
Almost
Yes.
$19,000. So anything that you can pay and however often you can start paying it is to your benefit. We will review this on the 1st of August at 1:00 p.m. And if nothing's happened at that point, I will consider jail time.
Alrighty.
All right, so Thursday, file with the courts and present to Ms. Baldwin's office the offer letter. I'm fingers crossed for you. I hope that works out. And I'm sure everybody does. And then we'll review this on the 1st.
Alrighty.
All right, good luck. Gilliam and Gilliam, 20-3-004298.
That matters. Ready?
And I'm sorry, Stockwell. It's not changed in the system, so I always refer to you as Gilliam until I see you on Zoom, Ms. Stockwell. So I apologize. We are here to review the amended tax return
And payments.
and payments.
So we're really in the same position that we were the last hearing. The court entered the contempt back in late June, ordered Ms. Stockwell to file her amended tax return, to file a copy with the court, provide me a copy. That has not happened. There's no evidence of her attempting to make that happen, of her like making any efforts really whatsoever. I do not see that at least anything that she's filed indicating that she's making payments. So really we have zero progress and zero attempts at progress. And again, in a case, and if the court will recall, my client tried to prevent her from filing this tax return wrongfully back in January. We waited, we made lots of efforts over about 6 months to get her to comply. She just was obstinate and refused despite a very clear order. We're really in the same position. There is no excuse on this one for something that's really straightforward. It is taking time and money out of my client's hands and out of the hands that are the ones that are responsible for feeding and caring for the children. So kind of similar to the last case that you heard, my thought is to kick it out 2 weeks, but if it's not done at some point, the rubber's got to meet the road and jail time is appropriate. I don't want to do that. I want compliance. But if Ms. Stockwell is just going to ignore the court's order, I don't know what other options we have.
Ms. Stockwell, can you update me on the amended tax return?
Yes, Your Honor. I did get that tax return amended on the 9th. In the wee hours of the morning, I was working on it over the weekend after I had dropped off the kids from my visit. I did get them amended, but after amending them, I was left with no money for gas money to get back down to file in the court system or to present Ms. Baldwin's office with a copy of this. I've also made a $90 payment to child support as soon as possible. I had to wait for my check to hit last week for that to go through because again, we were in the hole and didn't have money to be able to get down and getting that or to put any money forth for child support. And I think that was the topics. I'm sorry, my pregnancy brain is getting really bad.
All right, and I'm assuming, Ms. Baldwin, you haven't seen any payments come through at this point through, and are these payments going through DCYF?
Yes.
Okay.
And so my concern, very similarly, I'm gonna throw out my hands and make excuses. Those excuses just really fall flat. I couldn't get down there for gas. I have email. I have mail. The court has mail. She could, if she says she did it on the 9th, we're 9 days past that. She could have put it in snail mail and we'd all have it by now. I mean, she did, which leads me to suspect that she hasn't done it. So again, the concern there, there just isn't an excuse to not have, paid 60 cents for a stamp and put it in the mail. And so no excuse there. I don't think she's made a payment. She says she's going to make a payment ASAP, and a $90 payment is not cutting it. Again, there's not any excuse that she has. The child support order is, I believe, $480. And hey, I'm going to pay what amounts to a 20% of that isn't acceptable. She's not providing you any sort of plan for how she's going to even pay current support. It's just, I'll pay what I want to pay. That's not what the order is. You have to pay the court ordered amount. And so again, we just have somebody who says, I'll do what I want. And that is not appropriate. And so same request over 2 weeks, she needs to provide it. And if she doesn't and doesn't start making real payments, then jail time seems to be the only option to get her attention. Not what I want, but when people just sort of thumb their nose at the court, at some point we have to get their attention.
Unfortunately, the $90 was garnished from my paycheck and was half of my check. Therefore, we do not have the money to put forward yet. My husband does get paid this week and we can put more towards it. But I have paid as much as I possibly can up to this point, as again, with all of the bills and everything coming in. I am more than happy to provide proof of our bank statements or anything needed. And I have contacted Mr. Gilliam to get an email to send those, and he has refused. So I have not been able to email Ms. Baldwin. I can't find it online. I've looked in many places. And I'm not making excuses. I'm genuinely trying to do this. This has been a very big stressor. And I'm doing my absolute best at picking up shifts at work. I'm trying to do odd errands for people to make up money to be able to pay the child support.
I'm assuming Ms. Baldwin would be more than happy to give you her email address right here and right now if you have a pen and paper.
Yes, I do.
If she has it, I can just put it in the chat. That's probably easier.
Or that. Are you able to see the chat if that, Ms. Stockwell?
Yes.
Okay, so Ms. Baldwin's going to send you her email through the chat. I'd ask that the amended return that you said was filed on the 9th of July, please provide that to her via email. And if you can put that, if all you can do is mail it to the clerk's office, mail it to the clerk's office. That address is readily available online. We're in a situation where, I mean, I don't know. I know that you're currently pregnant. Is that correct?
Yes, I am due on the 2nd.
And the last thing we want to do is put you in custody, but you have obligations to other children that are still, that are here already in the flesh, and we can't, we have to be considerate of those children as well. So we'll set this to the 1st. You need to provide, email Ms. Baldwin by Thursday, the 20th, close of business with that amended income tax return, and please mail it to the court, the Superior Court Clerk's office, and then we'll review this on the 1st at 1 o'clock.
Sounds good. And we'll try to file an updated debt calculation for the court as well.
All right, thank you.
Thank you.
Kozad and McGregor, 2330020708.
Good afternoon, Your Honor. Amanda Holder here on behalf of Mr. Christopher Kozad.
Good afternoon. And Lilith McGregor?
I do not see her present, Your Honor.
All right. And I have
I'm
Ms.
here. I'm just
Powers.
on my phone.
Okay.
Thank you. And then I have orders that were presented by Ms. Powers. Have all parties received those?
I have received them, Your Honor.
All right, Ms. McGregor, have you received?
Yeah.
This? All right. And I didn't note any objection to those orders that were presented by Ms. Powers.
We have not objected to them, Your Honor, but this might be a little unorthodox. If we could set this case over on orders, my client has decided recently, as of today, that he is going to file an motion for amending the parenting plan that was currently put in place, seeking full custody. His daughter is about to start school in a few weeks and needs to be enrolled, and it is upon information and belief that there is an unstable environment, which we will be addressing in the petition for a new parenting plan. And therefore, it would not make sense to put orders in place for child support now if he is going to be seeking full custody.
And how soon do you intend to have that information filed and to be heard by the court?
I am directing my paralegal to begin drafting it today. She gave me an estimate of beginning of next week, we can have it filed. And we would be also filing a motion to shorten time, as his daughter would need to be enrolled in school within a month.
Okay, Ms. Powers?
I would request that we go ahead and enter the temporary order of child support. This child's been on TANF from May through July. TANF benefits are ending at the end of the month of July. The order that we've requested starts in May, and it would cover the TANF period. If the parenting plan ends up changing, it's easy to stop current support, but either way, the father's going to owe back support for May through July.
Yes, Your Honor. And one of the reasons we are going to change the parenting plan that was put in place is for the entire month of June and the last week of May, he was in custody of his daughter. And so again, it would not make sense to have him to pay the child support order when she was living with him, but Ms. McGregor was the one who's receiving the benefit.
And I would just note that the court adopted an agreed parenting plan submitted by the parties on June 20th.
All right. I did, and I believe looks to me as though Ms. Powers was present, indicated child support would be 441 and that we would be it would be set on for presentation. There was no objection at that point in time, and that hearing was on June 20th. So I'm gonna enter these orders. We can change them if need be. But I'll enter the orders as proposed. And then if there's any cross payments or any adjustments, we can make those if and when there's a motion filed, and I guess pending the outcome of that motion.
Thank you. And Your Honor, I had left the deviation section blank. If you could just check the box no on page 3.
All right, I have done that.
Thank you.
All right. And then Ms. Holder will stay with you. Move to Ivanov and Iverson.
Yes, Your Honor. And my client has informed me that it is pronounced Ivanov. No, Ivanov.
All right.
Ivanov. Excuse me.
Ivanov. Thank you.
Yes, Your Honor.
So it's 23-300-27108 on for motion for de facto parentage. I've received and reviewed everything that's been filed in this case. I do have, hold on. The only order I have in front of me is from Miss Iverson, and it is a restraining order, and I don't see a motion for a restraining order. Let me see here.
I apologize, Your Honor. I did miss filing that.
Okay. All right. I just didn't want,
I knew I had very limited time with the motion for the GAL, so I just responded and I completely left that out.
okay. Okay, because that Ms. Holder obviously would need notice to respond to a request for a restraining order. So we can still do that. We just probably can't do that today. So we'll address the petition for de facto parentage. I have reviewed everything that's been filed. Ms. Holder, any additional information you want the court to be aware of at this point?
Well, Your Honor, in light of Miss Iverson's declaration on the very last page, on page 6, she does ask that the court appoint a guardian ad litem to interview Adrian, and also the time to secure counsel to represent her. So I wonder if this is necessary right now, or if she would like to set the case over and have her future counsel address any issues going forward.
Well, at this point, Your Honor, I just wanted clarification as far as if the de facto parentage was going to be granted on kind of what avenue I was going to take. At this point, I am fully prepared to go ahead and move forward with a guardian ad litem. I would love for one to come in and speak with my children. He is almost 16. He'll be 16 in January, so he definitely has a voice of his own. I'm totally not opposed to having a guardian ad litem come in and speak with them. I also have a 14-year-old daughter who consistently used to go visit Debbie as well on a weekend basis, and she would love to speak with a guardian ad litem as well as to why her reasoning as to why she does not go there anymore either.
So, I mean, I'm just thinking here out loud. If
The other thing I wanted to, sorry.
One moment. So, I guess, Ms. Holder, is your client fine with essentially staying the decision on de facto parentage? I know that the request is for that to essentially start immediately. Is your client fine with staying that pending a GAL investigation?
Yes, Your Honor. Upon speaking with my client, I have advised her that it would be best going forward to wait on the de facto motion until we have a GAL investigation, because that would only strengthen her argument for de facto parentage. And we believe that in this case, it is necessary to have someone come in and interview Adrian and the other children to get a better bearing of this case, as it is likely to be very contentious.
Okay. And Ms. Iverson, are you hoping to try to get counsel moving forward if possible?
I am completely and capable of doing it pro se if need be, but I am fully and ready to have counsel take care of anything going forward if need be. So I'm prepared to go both avenues if needed, but.
All right.
Your Honor, Amy Powers here for the state. The child is receiving state medical, so we plan to get involved. But I had just wanted to make everybody aware, this child does have a legal father. There is a father listed.
I was going to say that, sorry.
So I just wanted to make everybody aware that there is a legal father of this child.
I believe, I appreciate that, Ms. Powers. Thank you. And I did see that in one of the responses filed by Ms. Iverson, that there is a biological father that is known, and I don't know how active in the child's life, but is present. So that obviously is a factor.
Yes, Your Honor, and we would be happy effectuating service on the father in this case, as he is also a person who has supported and fostered the relationship, which goes toward de facto parentage.
I would love for him to speak with the GAL, because that is not accurate.
Okay. If I could have, and Ms. Holder, are you willing to present a GAL order if we select a GAL today?
Yes, Your Honor, I am.
All right. Madam Clerk, if we could have the next three names.
Your Honor, we have Ann Height, Twyla Corey, and Keith Lawrence.
Any strikes, Ms. Holder?
No, I do not. And I would actually prefer Anne. I believe she's on the Zoom right now. If she is able to take the case, that would be wonderful.
Ms. Iverson, any concern with Ms. Height taking the case?
No, that is completely fine. I have been on FMLA since April. So as I did notice that there was some requests for me to cover partial of that cost. I just need to at least get some type of fair warning because I'm still on FMLA.
Okay. Here's what we'll do. And Miss Holder, I'm gonna allot at this point, given the nature of the case, the fact that your client has hired counsel, I'm gonna split this 60% petitioner, 40% respondent, 60% to the petitioner as private pay, 40% to respondent as county pay, and then to be reserved at a future date if there's different financial information found out about. So we'll appoint Ann Height. It sounds like there's potentially an amended petition to include biological father service needed there. That shouldn't prohibit Ms. Height from starting the process that she needs to start, but she would also probably need to send her informational packet to biological father as well. So if we have that information that we can provide her sooner rather than later, that would be great. So keeping in mind all of those things, how about a review towards the end of August?
Yeah, Adrian will be in school by then, and his trauma counseling will be down to every other week by then.
And I guess, Ms. Height, I wouldn't expect a written report from you. If you're able to get one, great, but I just want to make sure that all the information has been provided to you, and we have the amended petition. So how about August 22nd at 1 p.m.?
That works.
That works for me, Your Honor.
Okay. And Ms. Holder, if you're able to, we could set a presentation date for that GAL order earlier than that. Or if you feel you're able to route that through Ms. Iverson and present it ex parte, I can't imagine there'd be too much argument over that order. We can do it that way. So I don't know if there's a preference.
I can get it drafted up and get it over for signature so we can do it ex parte. Ms. Iverson, are you okay being served by email?
I am. I did want to go ahead and mention that the service that I got at Friday at 8 o'clock wasn't within guidelines. So I'm just asking that there at least be a little bit of time for me to get that.
All right, so I'll expect that order to be presented ex parte. Proper notice should be given to all parties. If for some reason we can't get that order entered ex parte, we could note it on a Tuesday or a Friday morning and have presentations. And I guess worst case scenario, we can enter it on the 22nd at 1 p.m. when we come back for review.
Okay.
All right.
Thank you, Your Honor.
Thank
you.
you.
Ms. Iverson, may I ask the court to follow up with Ms. Iverson if she is planning to obtain counsel at this time or no?
Yes, I'm going to obtain counsel.
Great. Thank you, Ms. Iverson.
All right.
You're welcome.
Good luck. We'll see you next month.
Thank you.
Judge.
Memo.
All right. Gibson and Gibson.
That matter's ready. First issue we have is presentation, and then we can take up the contempt. So we have really two presentations. When we looked at the file, we realized there was one regarding the home sale, and there was a cleanup one that had never been entered from May. So I'll address the home sale one first. There should be an order regarding home sale. Ms. Gibson filed objections. The only thing she's really objecting to is I'm asking for the home proceeds to be placed in my trust account. She wants it to be placed in essentially a bank account with both their names on it. That's just not appropriate. It should be a significant amount of funds. Ms. Gibson's already been found in contempt for financial misconduct in this case. Second, based on material she's previously filed, there are concerns whether or not she has fraudulently altered documents, again, leading to quite a bit of concern on what she would do to access those funds. She doesn't provide any other basis for putting it into a sort of traditional bank account instead of an attorney's trust account for safekeeping. There's just no reason not to protect the funds, especially when we anticipate the funds will be $150,000 or more. My client just wants the funds protected and have them placed in my trust account. So we're asking the court to sign the order as presented.
And when were those objections filed? Because I didn't see any objections.
Yeah, I can find it. Looks like she filed July 6th. It's Clerk's Papers 223, if that helps.
Their objection to proposed orders. Thank you.
Yes.
Okay. And I guess I did review that. Miss Gibson, any response there?
Yes, Your Honor. Putting them in a joint account gives equal access to both parties. You had previously ruled, because I'd also asked at that hearing where the court had decided for the home to be sold, that each party be allowed access to some of those funds, particularly because I will need access to some of the funds in order to move. And you said that you would reserve and consider that at the time when the home sells. I need access to those funds. Ms. Baldwin's accusation that I've documented or falsified financial records just isn't true. And it's also really easy to see if there's a joint account, if money's taken out, which person takes it out, where it comes out of. So there's no risk of money being moved without the parties being aware of it. And because you made that ruling that you would decide or that you would be willing to allocate some of those proceeds, it just makes sense to put them in a joint account. It can accrue interest during that time. Both parties can see where the money is, so that I can just know that if the court does make a ruling that I am allowed access to those funds, that I can get immediate access to those, that I'm not trying to have to work through Ms. Baldwin's office, which whatever delay that may or may not incur, that I have funds available should the court allocate those to each party. So that's my only concern. And I guess just a clarification point, I don't know if it needed to be in the presentation order, that when the realtor comes out, if there are any costs to any sort of, not upgrades, but any sort of costs incurring to getting the home ready to sell, that those be split equally among the parties, that I shouldn't be solely responsible for those, as petitioner is still on the mortgages for the house, and they are the party that wanted the home sold and not myself.
Okay. Let me start and then I'll turn to you, Ms. Baldwin. So I guess as to the trust account, there are very, 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 very strict guidelines on attorneys' trust accounts. And frankly, the historical posture of this case, I think the trust account is the appropriate place for the funds. If there is an allocation of funds, which I did reserve and said I would be willing to consider to allocate funds. There should not be a significant delay because it's in a trust account versus a joint account. There was, I believe, a contempt that was found previously for on a respondent for essentially doing the thing that you're claiming you're worried about happening to you. So I am not swayed by that argument. So I think the trust account is appropriate. As to any, and I appreciate Ms. Gibson raising this issue because I don't know if that was brought up. So if there is, something that needs to be done to the house in order to approve it for sale, I don't know that we address that. So Ms. Baldwin, whenever you're ready.
So on that issue, that really hasn't been raised in any declarations previously or any motions previously. Generally, because we do have a selected real estate agent, that agent will go through the home, make recommendations on what's possible, what's feasible, what's financially prudent. And then usually the parties work that out. So it's to both of their benefits to maximize the sale price. I'm not saying my client won't contribute, but the contempt that we have coming up next indicates my client doesn't have a lot of funds to do that with. And so I just don't think the court should address it. I have Ms. Evald's information. She readily communicates with me if there's some kind of repair or sort of curbside improvement, beautification. We can certainly talk about that. I just don't think it's properly before the court. So again, both parties are motivated to deal with improvements. Usually then the way we handle that is after the fact. Everybody provides receipts and that gets paid off the top. So I don't have any objections to those sorts of things. But again, those all need to be agreed on, things that Mrs. Evald recommends. And so I don't think the court should address it today. I just don't think that I don't think it's necessary. It's not properly before the court. It's something that I haven't historically had a problem handling when both parties are motivated to maximize the sale price.
So at this point, it sounds like there's a commitment to trying to work things out. If there are any bills or anything if there's a water heater on its last legs that needs to be replaced, whatever it is that's suggested, or if something comes back from a home inspection that, I think that can all be negotiated either outside of the court's purview or in front of the court if it comes to that. But my hope would be that the parties would be able to work together on those issues. So I am going to sign the order regarding home sale as it's presented. Then I have the order on hearing from May 30th. Ms. Baldwin.
Yes, we did provide that. I'll note we didn't provide a full week's notice on that. If Ms. Gibson is requesting additional time, that's fine. I think this was intended to be presented at a prior hearing, but we had some intervening surprise things happen. And so this sort of fell by the wayside. So I haven't received any objections to date, but she's had less than the full week.
Ms. Gibson, do you want to, are you prepared to deal with this today, or would you like more time to review the proposed order for on hearing from May 30th?
I would appreciate some more time. I was confused when I received it, what it was regarding or what it was about. So I am not sure how to address it because I didn't know what it was in reference to.
Okay. Do you, is 2 weeks enough time for everyone?
That's fine.
Does that work for you, Ms. Gibson?
Yes.
Okay, so I'll set over the order on hearing from May 30th to 8/1/23 at 1 p.m. And I made a note, Ms. Baldwin, on your original order in hopes the clerks will hang on to it for that 2-week period. Okay, and is there another issue that we need to address?
Yes, we're also before the court on contempt.
If I may, before you begin, Ms. Baldwin.
Go ahead.
For the court. So I have been in the process for a while now of trying to obtain counsel. I had a scheduled consultation appointment with counsel that got unexpectedly rescheduled due to an illness. I had hoped to have representation for this hearing. I am set to meet with counsel later this week. So I would request, since we just set a matter over for 2 weeks, to set this over, because I was prepared to have representation for this hearing today that, as I said, got rescheduled due to an unexpected illness. It's been very difficult, as I'm sure counsel and the courts are aware of, trying to get consultations with attorneys in family law matters.
I can't disagree with that. I'm sure appointments are difficult to come by. Ms. Baldwin, any objection to setting the contempt to 8/1?
Certainly do. Here's why. The contempt was originally scheduled for last week. Everyone understood that we were going to have that heard last week. That's why we put, the court will recall there was a restraining order. We put the restraining order on the same date because as the contempt filing, because that was already sitting last week before the court. And I said I didn't care what judicial officer heard it, and Ms. Gibson said I want to hear it as soon as possible. So last week we come before the court. Ms. Gibson then, despite having filed a response, basically says, well, I don't want it heard. Makes no mention of finding counsel, kicks it over to this week at her request for continuance. Here we are yet again. Again, she's filed her response. Nothing has really changed. Counsel may come in or may not come in. We don't know. But the reality is we're in a position where we've already had, this is the second hearing where we've come before the court on the contempt. Everything's filed. I think it's appropriate that my client receive relief. The children at this point are suffering very real consequences, and the idea that we put it out is not reasonable. My client, because of how we time these things, my client's already waited a month to have this heard. The idea that it takes 6 weeks to get a pretty straightforward contempt heard isn't reasonable. So we ask that we go forward today.
All right, and I do see, so Ms. Gibson, you did respond. And the last hearing I was at, I do note Ms. Baldwin's correct that there was a request for this to be heard as quickly as possible. So that was set on to the 11th, and then it was continued to today, the 18th. So given that this was filed, looks like the 12th of the 9th of June, and we're at the 18th of July, and this is the third date that we've had since this has been filed. We'll handle this today. All right, so Ms. Baldwin, go ahead.
Thank you. This is a very clear-cut matter of contempt. This is for failure to pay daycare fees as apportioned by the order of child support. That is a child support obligation. When the court looks back at the record, you'll find that the court largely adopted Ms. Gibson's proposed statements about her income level and her proposed proportional share of the children's expenses. At that time, and throughout the case, essentially until this contempt was filed, Ms. Gibson repeatedly told the court that she could afford to pay all of her obligations so that she could avoid having the house ordered to be sold. Again, and it wasn't just that she could meet all of her obligations, she could meet those obligations and refinance the house in order to be able to avoid it being sold. So she said that she could refinance and increase what she was paying. This is what she told the court she was able to do. Now she comes before the court and says, oh, I can't pay it all. Let me make $50 a month payments, even though the obligation is somewhere in the hundreds and hundreds of dollars. Let me just pay $50 and not pay anything more. So which is it? You can't have it both ways in essentially a 6-month period of time. Either you can make all your obligations or you can't. And the reality is that Ms. Gibson will tell you whatever she thinks is going to get her what she wants on that day. I think it is notable that Ms. Gibson previously had a second job. She quit that job. That's a job that is not considered in her current income as set for the purposes of child support. So the court did not assess her to have that, but she did have that historically. Again, it's undisputed. There's a court order for her to pay, that my client kindly sent her the billings, and that she, for the vast majority of it, has not paid. Her claims that there are, I've made $50 good faith payments, that is not good faith. That is a, please don't send me to jail, but it is absolutely, I'll pay what I want. So I'll just keep paying $50 so that you don't throw me in jail. She's not providing her bank statements. She's not saying, here's all the expenses I've cut out. Gee, I've cut my cable, my phone down to the bare minimum. I've cut this expense and that. There's none of that. It's sort of just, gee, I can't pay. I'm just going to throw my hands up and to say that that's an excuse. Again, notable from, she only started making these payments, I believe in March or April. Children have been in daycare since January. And again, she's just making essentially a $50 payment toward what amounts to $1,000 bill. That is not good faith. When you look at her income, again, just blatant dishonesty with the court. She'll tell you what you want to hear the day you want to hear it to get her way. You look at back in December of 2022, she claimed, and we put it right in the reply, that her net income was $3,189. This is her statement. We are now 7-8 months down the road. If anything, she's gotten a raise, but now she claims that her net income is $700 less a month. Well, that $700, there's just no evidence that supports a reduction of $700 a month in her income. No basis for that reduction. And if she had been applying that $700 a month toward the children's daycare expenses, we wouldn't be in this position. That would be good faith to say, oh, this is every bit of extra I have. So again, even within the course of 6 months, she's just talking out of both sides of her mouth. These claims that, oh, gee, I self-helped for offsets. Those are really throwaway arguments. First, latches in the sense it was never raised until my client said, hey, you owe this child support obligation. Never once raised in the more than year she says that obligation existed until my client asked for payment. So if it was a real obligation, she should have been asking for it from the minute the order was made. Two, if you're using basic law school contract principles, the order is construed against the drafter as to any ambiguity. This was drafted by her counsel at that time. And two, three, you can't self-help. This idea that, oh, well, I'll just offset these things is not appropriate. But we do have two prior contempts in this case, one regarding finances, one regarding the parenting plan. This would be the third. There are very real consequences to the children of this action. The children have now been removed from daycare due to non-payment. That is a very real negative consequence that the children of this action now have to deal with, and that my client has to deal with, because he can't afford to manage everything on his own financially. The child support is a right of the children, and this is just saying, I'll do what I want. I'll pay what I want, sort of shrugging her shoulders at the consequences. And that is not appropriate. This is somewhat a disaster at this point because it takes so long to have these matters heard. It's really a disaster of Ms. Gibson's make. She's done something that has financially harmed everyone and is actively harming the children. Daycare spaces can be precious, and getting them back is a question mark on whether or not, even if she pays now, there may be now a waiting list where my client has to choose more expensive options because that's all that there is. Given this, the order only calculates arrears through June. That's fine. Arrears through June for the daycare obligation is $4,490, $318 of interest. I am asking for a substantial amount of fees of $3,500. That considers the set over from last week. That considers today, all the efforts to get her to pay. But it also considers the fact that when we dealt with the motions, the court had reserved previously sort of fees on the motions regarding the house. And again, when you're being blatantly dishonest before the court and saying, I can meet all my obligations and afford a refi increase, but that delayed the sale of the house, which would have provided funds for my client and would have freed up money because Mrs. could choose cheaper housing. She's really, again, created a financial disaster for these parties by being dishonest with the court about her finances. I'm asking for a civil sanction of $1,000. Again, when you have somebody just blatantly lying to you in a pleading where I can put captures of look at this and look at this, and these are the dates that she did it, and told the court one thing and then told the court something that's significantly different, that's sanctionable. It just is. And finally, cost of $750, or I'm sorry, cost of $75. Finally, because the court has ordered the home to be sold, what I am asking the court to do is authorize that my client will be made whole any judgments that have been entered to date in his favor against Mrs. That will allow him to catch up all the daycare payments. And those would be then establishes against her community portion whenever that is later decided. I think that is a relief that's necessary and appropriate. Again, my client needs these children to be in daycare. He needs to work. He works full time to support the children. So we need to be in a position where we're making appropriate use of those proceeds if and when they become available. So again, really a problem of Ms. Gibson's making, and frankly, the old adage, what a tangled web we weave, that is the position she is in. And so at some point we have to deal with that. And I think that's today.
All right. Thank you very much. Ms. Gibson, your response?
Thank you, Your Honor. We're here today for something that I feel shouldn't even necessarily be in front of the court today. Ms. Baldwin is correct that I've been making weekly payments to petitioner. If you look at my financial declaration, that extra $700 is for child support that is coming out of my check now, since petitioner has had the children. And at this point, I thought that things would have been different with all of the extra things going on with the children. I thought that I would be able to refinance the house and do those things under the assumption that what I was, told by the courts, this step needs to happen, this step needs to happen, this step needs to happen for the kids, that I would get the children back and potentially be getting child support payments again. And that's clearly not happening at this stage. So as I showed in my financial declaration, I'm making payments to him in good faith because I'm already in the negative for all of my bills. I'm having to pay all the house payments. I have greatly reduced all of my bills as much as I can. I need a phone bill. That is the smallest phone bill that I could get. I cut all of my cable. I just have basic internet. I don't spend excess money on groceries. I don't spend money on myself. I can't afford to make these full payments at this point to petitioner and also keep a roof over my head or make my car payment so I can go to work. So I'm not quite sure what Ms. Baldwin or the court expects me to do. I can't do all of it. And then to talk to the point of Ms. Baldwin's point that I started making $50 payments to petitioner back in March. That was after months of trying to get this offset for petitioner still not paying his court-ordered obligation on the house, which is his half of the homeowner's insurance and his half of the property taxes. It's been addressed in multiple pleadings, so I didn't touch base on it too much in this response declaration. But back in November of 2021, Judge Scudder approved that initial separation of expenses. Then in March of 22, Ms. Baldwin and my attorney at the time, Ms. Winkles, had a whole hearing about it in front of Judge Scudder, who ruled that he wasn't changing any of those obligations. And payments still weren't made. It was advised to me when I had counsel that I could just, since I was able to afford.
Is way beyond the declarations and citing lots of hearsay. I've kind of let it go for a while, but at some point she needs to hold herself to her declaration.
All right, so yeah, let's refocus onto this contempt. Ms. Gibson, I know in your responsive declaration, you alluded to a contempt you were filing. I don't know that you did file that contempt, so that's a little bit beyond what we're dealing with today.
Okay, Your Honor. Yeah, I'm having difficulty trying to figure that out since I don't have counsel. I guess what I would say is I've been making these good faith payments, even though I don't have the money to make those payments. Petitioner lives at home with his parents. To my knowledge, he doesn't pay rent. He doesn't pay the mortgage. He works full time. He makes twice what I make. His mom is retired and stays at home and watches the children. Even before he established them in daycare, which is a daycare that he put them in that I wasn't notified about until months later. In our parenting plan, we still have joint decision making, and I'm not being made aware of where my children are seeing doctors, where they're going to daycare, any of this. So I would just ask the court not to find me in contempt. I'm doing the best that I can with the money that I have, because at this point, it's either I pay the mortgage or I pay childcare. And I don't know what counsel or the court want me to do. As you can see in my financial declaration, there just isn't, I don't have the funds to pay that full obligation. I'm doing what I can. I've tried to get the other outstanding issue resolved, which the court has acknowledged at least twice. That petitioner is still not paying, which is now leading me to have to try and file a contempt motion for something that the court's verbally ruled on, which to me just seems like a waste of the court's time, but he's not meeting obligations on his end either. I'm doing the best that I can with the money that I can provide without making myself destitute and making myself not be able to make all of these other payments that I need to make each month in order to survive. So I'm just doing the best that I can, and I hope that the court can see that. And I want to provide for my children. I'm just doing the best that I can right now.
Right. Thank you, Ms. Gibson. Ms. Baldwin, anything else?
Just briefly, paternal grandparents have been gracious in their efforts, but they are not obligated to be full-time daycare providers for free for Ms. Gibson because she doesn't want to pay. They attempt to sort of muddy the water of, gee, all these terrible things have happened. A, we dispute those, and B, they're not relevant to today. But the reality is we have somebody who isn't providing you with bank statements, isn't providing you in advance of sort of hearing my argument of the things that she's cut out of spending. And again, we have a court order on what her obligations are, and she's getting the bills and just shrugging her shoulders. It's not appropriate. These children are facing a real consequence, or at this point have faced that consequence, are in the middle of that consequence for her non-payment. Payment should be made. We're asking for the arrears and the fees and sanctions as I've ordered. And then finally for the judgments to be apportioned out of Ms. Gibson's any award that she has, but paid immediately from the sale proceeds of the house, so that hopefully the children can return to daycare shortly.
All right, thank you. So I'm looking at the temporary order of child support that was entered in December of 2022 by Judge Scudder. And it does appear that Judge Scudder deviated downwards from the state, essentially the calculation, the standard calculation for child support. Not only just in the standard calculation, but then took off another $250. I'm assuming there's a reason for that, but there's a transfer of $552 a month for child support. And then a 60-40 allocation for uninsured medical costs, work-related daycare, preschool, and the like. So 60 to Mr., 40 to Mrs. it's, that order is cut and dry. I understand Ms. Gibson has concerns with the previous order of the court and the mortgage, the home insurance and it's escaping me now, but I understand her issue. And the concerns with that, that's not before the court today. I also very much sympathize with Ms. Gibson's position. If everything, assuming everything she is saying is accurate, that it is a difficult situation to be in when you feel you don't have the finances to cover one versus the other. So frankly, I think it was appropriate to make the decision to sell the home because I don't know how Ms. Gibson, given the situation she's claiming to be in monetarily, how that would have ever worked. And two, this is a pretty straightforward child support order. And it appears as though while there's attempts, there's also a failure to be able to provide those. And unlike a lot of cases, it does appear that this has already negatively impacted the children in this case with their removal from any daycare programs because there's just no money to pay for that. And the lack of payment from the respondent. I'm not unsympathetic. I do think based on, again, the historical posture of this case, I am going to make a finding of contempt. I will, and I don't have, did you present an order on the contempt?
I did. Let me see if I can see what was filed. Filed July 11th. If you don't have a hard copy there, we can deal with presentation if you'd like when we come back in 2 weeks.
Okay. I don't have that. I am not, and what I'm the back costs, the interest, standard costs. So the $46.90, the $319 interest, $70 in costs, I'll adopt all of that. At the civil sanction, I'm going to reduce to $500, and the fees I'm going to reduce to $1,500. All of that, I don't expect Ms. Gibson to be able to pay that money. I want her to stay as up to date with the support order that sounds like it's being garnished, and make as many payments as possible. But ideally, if the house can get sold, I think it's appropriate for those to be just subtracted from her side of any award for the return on the house. So we'll set presentation to the 1st. And then I don't know if Ms. Gibson is planning on filing a contempt, if she gets, or how quickly that turnaround time can be. I think we all know based on some of her declarations what she intends to file the contempt based on. But with her meeting with counsel later this week, we may not be able to address that. And obviously the court, what I don't want is a lot of transfer payments back and forth. So we'll can look at any offsets if and when there's a potential new contempt filed by either side and the ruling of the court. So we'll enter that order, and I don't see it. I had 2 orders in my stack related to Gibson. One was the house sale and one was the May 30th order. So we will do presentation on the 1st along with the other reviewing the other order.
So only request is at this point, because the children have exited daycare, it is a set sum that she owes. We'd ask that we just be able to update that full amount of what she owes through the day the children exited care.
That's appropriate. So if those numbers are different on the 1st, we'll enter the final number on that date.
Very good. And I believe we've already filed a copy of the daycare billing. I'll just make sure that whatever billing is in the record goes through the date that they were last in care.
All right, perfect. All right, thank you. Good luck. We'll see you on the 1st. Men and Men, 23300159008.
That, there we go. Sorry, Your Honor, my internet is terrible here. Ms. Bliss and I have spoken, and if Your Honor needs argument, great. If Your Honor's read it and would like to give a decision now, that's great. Or if Your Honor would like to email us with the decision, that's great. We believe we've laid everything out in the declarations, and Your Honor can make the decision.
And I would concur with that position, Your Honor, depending on what Your Honor needs from us today, or if you want to take this in chambers and give us a email ruling, that's fine as well. Ms. Winkles and I have spent a lot of time on this case and just simply need a ruling from Your Honor to figure out how we move forward from here.
All right, let me just, I may have a few questions. Okay, so there was initially a request for $5,000 in attorney's fees. It's now changed to $10,000 in attorney's fees. There's a request for support, $1,500 a month for a period of 2.5 years. And I'm trying to remember. This is Mrs. is in employed in, I think, Multnomah County. Is that correct? And he's employed at the railroad. Okay.
Correct.
All right. Sometimes
Yes.
I worry that I get some of these things confused.
We requested the 5,000 first, so we'll go with that because that's actually what's in the motion. The 1,500, really just the pendency of litigation until we get to trial. I mean, 2.5 years is what she wants based on the term of the marriage, but 1,500 just pending trial or settlement is good, pending further court action.
Okay. It sounds like, so there's a little discrepancy as far as what Mr. salary is, and it has, I did notice in some of the documents that were filed that there was an increase more recently over the last couple of years. There was few increases and
I believe the discrepancy, our argument is that it's the tier 1. Railroad has tier 1, it's Social Security essentially. And their argument, I believe they're using one of the prior year tax returns, I believe. Is that right, Carly? And so that's where the discrepancy comes from. We use the 2 pay stubs, the Social Security, extrapolated from the 5 months that show on there to what the whole year would be. And Ms. Bliss used last year's tax.
And Your Honor, as contained in my client's declaration, he is providing post-secondary support for his child, and he acknowledges to the court that he does work some overtime now to not only pay for that, but also for attorney's fees, and that's not expected long-term.
all right. I'm gonna give you a ruling right now. Just give me one moment because I want to pull up. I should have flagged it. Just give me 1 second here. Okay, so I'm going to adopt standard temporary order language. So all assets should be maintained. And if there's there's a request I know for the respondent to be able to get some items out of the home. I didn't see any real issue with that. So if that can be organized, so I'll authorize that to occur. The insurance should stay where it is. So Mrs. should remain on Mr.'s insurance pending any further order of the court. So no change of any insurance. I am going to I'm going to reserve on any community debts or interest. I understand that there's some disagreement as to the refinance and the mortgage of that, and that Mr. was awarded the house previously, but there was a refinance and some potential updates, so that'll be reserved. It appears as though there's no objection to the request on the temporary order to not share the address with petitioner, but for the concern if she becomes unrepresented moving forward, Ms. Bliss would need access to her whereabouts to serve her moving forward. So I'll authorize that, barring that instance. As for, frankly, I didn't see, there is a difference in incomes here, and clearly Mr. does have some relatively significant funds monthly going into retirement and other savings type accounts. I recognize that. Taking everything into consideration, I'm going to authorize a one-time payment of $2,500 from petitioner to respondent for attorney's fees. And we'll put a paid within 60 days. And then starting August 1 for a period of 6 months. I'm going to authorize spousal support of $700. And that's for 6 months. And then that'll terminate at that point in time. Is there anything I missed?
I think that covered everything on my end.
And that's everything on my end as well, Your Honor.
All right. I'm assuming we can have an agreed order presented ex parte?
Absolutely.
All right.
Ms. Winkles, I can fill draft.
I'll do that. Not a problem. I'll give it to you tomorrow. I say tomorrow. It's not believe me. Let's say.
We all know what tomorrow means.
Thank you, Your Honor.
All right. Thank you. Good luck.
Thank you, Judge.
And then Emptor and Suite 223-0042408. All right. This is motion to amend temporary orders to adopt GAL recommendations. And so I'm assuming everyone has seen Ms. Turnbull's report.
Yes, Your Honor.
I have reviewed everything and I'm ready for any additional arguments. So I'll turn it to counsel.
Sure. Your Honor, just before we get into argument, I did have a couple housekeeping measures. I was going to make an objection as to the 3 supplemental declarations filed on reply.
The Berg, Bow, and Sweet.
Correct.
Okay, go ahead.
And Your Honor, those were in direct reply to items that were brought up in Mr.'s response that were not specifically brought up in our motion. And so we felt, I mean, we're entitled to under local rule because we hadn't filed any third-party declarations with this motion, but they were specifically in reply to specific incidents that these persons had firsthand knowledge about.
Okay, Ms. Bliss?
And Your Honor, this does exceed local court rule 88, which allows for 4 pages on reply. That's 4 pages total, not 4 pages per persons. If Your Honor looks, Brianna Sweets, I believe, was 3 pages. Deborah Bergs, I think, was 2 or 3 pages. Same with Ashley Bowe. And Ms. Sweets was in and of itself 3 pages. All of that exceeds local court rule 88.
Okay. I'll note the objection and consider what does comply. So I guess outline in any argument if there's anything specifically that you want the court to refer to in those declarations.
Okay, thank you, Your Honor. So this is our motion. I represent Roxanne Sweet. This is our motion to essentially amend the temporary parenting plan from last November and to adopt the GAL recommendations. I think what you have here and looking at kind of the total picture and then looking at Mr. Empner's response, he kind of brings up new things, but he really rehashes a lot of what was put in his initial materials. And so the concerns that he alleged about my client that was put in his petition to modify and in his materials that kind of led up to the parenting plan that we have now, those are the same. He doesn't bring up new allegations. He brings up the same recycled allegations and then wants to undercut the GAL and say, well, the GAL didn't do a very good job. Well, not only has my client been under the purview of the court since September, she's been under the purview of a psychological evaluator who was able to perform the evaluation with collateral contacts and a review of the court file. She's also been under the purview of a guardian ad litem for this entire time. And so for Mr. to come back and say, well, all these people have got it wrong. Here, I have it right because I don't like the recommendations. I think it's pretty clear what he's doing. So just to highlight a couple of the statements, because I actually think both Dr. Deming and Ms. Turnbull made some pretty compelling statements in their reviews. Not only did they corroborate everything my client's been saying since the beginning, which is, I'm not on drugs. I've been sober for 5 years. I'm able to parent my children. I don't have mental health issues that inhibit my ability to be a parent. That's what my client's been saying all along. And these professionals, for the court's consideration, said mom's been telling the truth. To the contrary, it's been dad and specifically dad's sister who have been making false statements, and I'll get to that in just a second. So essentially, if you look at the GAL's, well, first we got Dr. Deming's report, and then we got the GAL's findings, which kind of incorporated that. A couple things that I think are important to note is one of the concerns of the court with the information presented at the initial hearing was if my client was experiencing some sort of mental health crisis that really was tied to her ability to parent. Dr. Deming's evaluation found that she did not meet, and I'm quoting, the full diagnostic criteria to qualify for a specific mental health disorder, nor was there impairment from psychiatric issues that precluded her ability to safely parent. And that's from Dr. Deming's report. The GAL found that there's no reason my client shouldn't be returned to her status as primary parent, and that she historically had been. And I think that's important. Both of the professionals during their evaluation and a lot of the third parties confirmed the fact that my client had always been this child's primary parent until being removed and forced to go under supervised visitation. In fact, the GAL found that there was evidence of domestic violence in my client's relationship with the petitioner, perpetrated by the petitioner. And I realized that he put in his responsive declaration, well, there's never been a claim of domestic violence until now. It's not like my client went in and hired these people to investigate whether there had been or hadn't been. These people came up with it of their own volition through their investigation. So I think that's very telling. My client has been in therapy for that and other issues, which both of the professionals acknowledged. But the one thing that I think is telling is when you look at both reports, neither of them have a negative thing to say about my client. Now, again, she's not perfect. She's certainly made her waves in this world and she's worked through them, but neither of them said she's doing this wrong. She lied about this. On the contrary, when you look at the allegations that Mr. Emter raised against my client, they specifically said that his allegations of a drug relapse have not been borne out by any facts other than claims by him and his sister. Same thing with this allegation of a mental health crisis. And the GAL, quite frankly, said to the contrary, I found objective evidence that Mr. Empner was the one using drugs, at least close to the beginning of this process. The GAL continued to say that this investigator is seriously concerned that Mr. Empner has knowingly made false accusations against Ms. Sweet, keeping Grayson away from his mother to improve the likelihood he will receive 50-50 custody. And so knowingly made false accusations, that's troubling. That is indicative of somebody who's not going to support a parenting relationship in the future, should that person remain equal or even primary parent. So I won't go into a tremendous amount of more detail other than your honors read the GAL report and Dr. Deming's report. Again, you're going to hear the same things that you heard at the beginning of this case. And I understand why the court erred on the side of caution because some of the allegations were concerning. We've now had 2 experts and the court watch this case for the last almost year. And my client's been nothing but a model parent. She's exercised all of her supervised visitation. She has not foregone visitation. She's exercised as much time as she can. And these little issues that he raises about her parents or the potty issue, all these things, he's grasping at straws to try and make it look like she doesn't know how to parent. She clearly does. All the professionals in this case said she was the primary parent and were troubled that dad was outright telling lies. We are asking the court to adopt our proposed parenting plan. And I will put for the court's reference, my client's not trying to slap him with 191 restrictions. My client's not trying to go for sole decision-making. My client, in fact, proposed more visitation than what the GAL proposed per week. So we are asking the court adopt our plan in total. And the reason why our plan has a couple tweaks is depending on if dad's working, what shift he's working, he might not be able to have Grayson like on those traditional dinner visits. So we put specific language in there that if his shift changes, those dinner visits are not possible, my client will work with him. But again, you have my client who she's hurt, rightfully so, and she's frustrated and she's upset. She could have come to court and said, you know, look at this guy. He's the one who needs supervised visits. She's not. She acknowledges Grayson needs his dad. She wants to work with dad moving forward and hopefully get this part behind them. And would ask that the court adopt our parenting plan. Now, we did indicate that we tried to work this out when the report came out, and I know settlement offers are not admissible, but I would just point that out for the record because we are asking for fees. I realize dad is asking for fees too, but we did try to address this outside of court immediately upon receiving the GAL report to no luck, and that's why we're here today. So if your honor has any other questions, I'd be happy to answer those.
Thank you.
Thank you.
Ms. Bliss.
Thank you, Your Honor. And as the court is aware, I do represent the petitioner and non-moving party, namely David Empter. Before the court today is mom's motion to modify the temporary orders. Regardless of the basis as to why the request is before the court is held by statute to consider the best interest of the child. And that's what we're asking the court to do today. In my client's responsive declarations, he points out a lot of concerns that he had with the guardian ad litem's recommendation. Yes, there were a lot of concerns that were brought up initially at the beginning of this case that weren't addressed in that investigation, but that is the crux of his concern. As Your Honor may recall, you were the one that made the initial ruling in this case, and what we brought to the court was a concerning video, which was never addressed by Ms. Turnbull, which was never addressed by any of the other professionals in this case, and that is the sole purpose of my client's initial request to have all of the evaluations completed and to have supervised visitation. In that video, Ms. Sweet exposed the child to not only name calling my client, singing, appeared to be in some sort of psychotic episode. That transcript and the video in and of itself was provided to her prior counsel, which was before Ms. Rush's being retained in this matter. But the court had significant concerns, as did my client. None of that was addressed with Ms. Turnbull's report. None of that was addressed with the evaluators and the professionals in this case. And that is why my client still has concerns. My client acknowledges, now that we've received compliance reports from Ms. Sweet, now that we've been informed that she is continuing to take UAs and seek treatment, that maybe we can chalk that up to it being the beginning of a case where we know tensions and emotions are high. Maybe that was the cause of it. However, my client stands by his initial concern, whether it was a mental episode, whether it was substance abuse, or simply high emotions, the behavior was inappropriate. That, coupled with giving the child vials and needles and taking photos, which she acknowledges was a mistake. Again, that's growth on her part, and my client acknowledges that she's grown throughout this process. But again, the court is charged with determining what is in this child's best interest. What is in this child's best interest is remaining with his father. My client acknowledges that Ms. Sweet has grown in her parenting. She's taking parenting classes. She is seeking counseling, which we just received on her reply. We received those compliance reports, which are wonderful. Had we had those at the time of our response would probably have been drafted a little bit differently, proposing something else. At this point, my client is eager to provide Ms. Sweet additional visitation. However, drastically changing the life that this child, who isn't even 4 years old yet, has been accustomed to for the last 9 months of his life is not in this child's best interest. What Ms. Turnbull failed to do in her investigation, which I know this isn't an attack on Ms. Turnbull, but I do think it's important for the court to understand, Ms. Turnbull didn't speak with Grayson's teachers, didn't speak with Grayson's caregivers, didn't inquire as to his growth. My client provided in his declaration, not only is Grayson enrolled in Montessori school to start in this fall, he also is engaged in several extracurricular activities, t-ball, swimming, soccer. No longer is required to seek services at Progress Center because his speech has drastically improved. He's potty trained. I mean, I know a lot of these are natural milestones that children will reach throughout the course of a case, but it is important for the court to know that all of these things have happened while this child has been in my client's primary care. He's attended every single doctor's appointment, every single dentist appointment. He provides for the court that when this case first began and when the child was first born, we were in the middle of a pandemic. Ms. Sweet acknowledges that only one parent was permitted to go into the doctors at one time. And that's my client's position. He was unable to attend every single doctor's appointment, because he's a shift worker. And as the court knows, in a typical household, if one parent is working, the other parent takes the child to the doctors. That is not indicative of her being the primary residential parent. Nevertheless, we need to look at the current picture. The current picture is this child who's not even 4 years old, has spent the last 9 months primarily with my client and with mom for 5 hours per week on a supervised basis. If the court, and I understand that the request of Ms. Sweet is to adopt the guardian ad litem's recommendations, kind of, with some tweaks. But if the court were to look at the guardian ad litem's recommendations, I think that you'll see a significant concern. How is taking a child, not even 4 years old, going from five hours a week of supervised visitation with mom and 99% of the time otherwise with my client, to reverting to primary care with mom, seeing my client for 1 day every other weekend and a couple hours during the week. That's absolutely contrary to this child's best interest. And I'm afraid that the court makes this determination on a temporary basis without all of the facts being borne out, without testimony, without evidence, without other corroborating statements and the like being provided to the court on a trial basis, that this is going to set this case on a trajectory that may not be and is currently contrary to the child's best interest. So we are asking the court to maintain status quo to an extent. Again, given the fact that we have received some compliance reports and some UAs from Ms. Sweet on her reply. Again, that was not received prior to our responsive declaration, so I'm ad-libbing here. My client is agreeable to providing Ms. Sweet additional time. However, switching this child's primary custodian, at least at this juncture, is not appropriate and is contrary to his best interest. I'll defer to the court as to what that visitation looks like. My client acknowledges in his declaration that Grayson needs his mother. He's not denying that. He just wants her healthy and capable of parenting. And it seems now versus when we were first before the court in September and October, it seems that we're getting there. But it is contrary to this child's best interest to be taken from the one home that he has known for the last 9 months to going to no visitation with, or virtually no visitation with his father. So we are asking the court to either deny the motion in its entirety or approve to an extent, maintaining my client the primary custodial parent and providing Ms. Sweet with some additional time given her significant strides over the past 9 months, 10 months, which my client does not deny.
Right. Ms. Rush, anything else?
Just briefly, just to correct the record, and this was partially my client's reply declaration. The GAL did address the whole needles issue with the video and the pictures. That's on page Bates number 35 of our submission. So I just want to make sure that that's clear. And then, counsel kept saying it would be too drastic and not in Grayson's best interest to rip him away from the person who's been his primary parent for the last 9 months, and that is pursuant to court order. I would just argue to the court that it was probably similarly drastic for Grayson to be ripped away from his mother, who all professionals have corroborated was his primary parent. She didn't work, she stayed at home with him. So that it goes both ways. I also just find it interesting for dad to say that he's proud of mom making strides, and he's willing to offer her some more time. Well, he told the GAL on multiple occasions, and it's in her report, that he wanted a 50-50 schedule with mom. So which is it? Is she so terrible that she can't parent this child, or is she just as good as dad is, and so therefore a 50-50 would be appropriate? My client's not pursuing a 50-50 because that's not what the professional supported, nor is it historically representative of the time that Grayson had with both parents. But like we said, she is offering more time than actually what the GAL recommended. I know the GAL is on the line if your honor wants to hear from her as well, but I think that's all I had.
All right, thank you. Ms. Turnbull, anything that you want to clarify or add?
I think it's in Grayson's best interest to have time with both parents. I do think both parents have some deficits that they could improve on. And I think Ms. Sweet has been actively working on hers throughout the year. I don't know that Mr. Emter has addressed some of my concerns regarding his, and that's a concern.
Which he would have found out about in your GAL report that was filed in May?
Correct. Yeah, the specifically domestic violence evaluation. And I think the counseling that would potentially go along with that.
Could I inquire as to, because the recommendation is pretty much the opposite of where we're at now. Is there a reason why there wasn't a more equal recommendation for parenting time?
For parenting time? Because prior to the court order, mom was doing the primary parenting by all accounts. I mean, other than dad's, by all accounts.
Yes, and
dad has shift work. And so I thought it was more appropriate that mom have the primary custody and the visitation occur around dad's schedule. And my concern also was that he follow through with the domestic violence evaluation and then go from there.
Right. And thank you. Miss Bliss, did you have any conversations with your client about doing a domestic violence evaluation?
He's more than willing to, frankly. Sorry, Hunter.
No, go ahead.
He is more than willing to. In fact, we did have a conversation in my office where he indicated that he was going to speak with counselors, speak with getting an evaluation done. It was at my advice that we wait until Your Honor's ruling on that. Given the allegations within the report and the allegations of Ms. Sweet, obviously the discussion in my client's declaration was that those allegations are false and retaliatory. If Your Honor orders him to go and get an evaluation, he'll schedule it today. He has no objection to that.
Okay. Thank you. So this is a very interesting case. And we have a young child here. We have two parents that clearly want to be actively involved in this child's life moving forward. And that's great. We, frankly, a lot of the time I look at these types of cases and I start out, it's a 50-50 plan. And then when there's issues, that's where the line moves one way or the other. Clearly, last year, there was concerns, and Ms. Bliss indicated it was me that made the initial decision. That's entirely possible. I just didn't look that far back for the parenting plan as it sits now. There's nothing that I've read thus far that shows that Ms. Sweet didn't do everything that was asked of her and do it comply with everything that the court asked of her. There's been no reports, negative reports as far as any visitations, anything like that. So to me, where that puts us back kind of in a middle ground. Primary parenting, historically, I don't like that being the marker. I really don't. If someone stays home and someone works, then that means that someone who stays home always gets their child. That's not fair. I don't like looking at cases that way. I think it's we often really doesn't favor one parent. Clearly this child is young, and we like to say kids are resilient, but frankly, in these situations, they're the ones that are put through the stressors as much and sometimes more than the parents. I do note that there's some concerns that were raised about Mr. Emter throughout this whole process. I think just to clear things up, that domestic violence evaluation with collateral input is probably appropriate, so I will order that. But there have been no issues with him having the child for the last, so I think November was when that order was entered, so 8 months, 8 or 9 months, so which is good. What I'd like to see is something that is, they both parties live locally. The child will be starting school this fall, correct? Montessori, at least. I'd like to see something along the lines of a more of a 50-50 plan. I'm hesitant to say, let's change everything right now, because we could get a domestic violence evaluation that says something completely different in a month from now. But I do think that what I'd like to do, and I guess what I'm considering doing here is, so I'm looking at the parenting plan, temporary parenting plan from November that requires non-professional supervisor for mom 2 times a week, 3 to 5 hours a week. So that's been happening for 8 or 9 months, as I stated. And then she did the evaluations. We have all that now. That's great. So I kind of want to do, it's going to be a phase up, and this will give Mr. Emter time to get his evaluation completed. So I'd like to modify that to allow for Miss Sweet to have a weekend, unsupervised weekend with the child.
And Your Honor, if I could real briefly, my client she does have 2 pre-planned trips. If we could work these in, one is the weekend of the 21st through the 23rd. She's going camping with her family. And then the long week, or I don't know if it's a weekend or week, but August 18th through the 22nd, she's going to Sun River with her family.
And Ms. Rush, are you asking that the child go with her, or are we trying to work around that?
Correct. I think she'd like the child to go with her, so.
Okay, let's start with this weekend camping. That sounds like with her family, and that would probably be a great experience for the child. So let's start with, and then you said August, I'm sorry, what was the next one?
18th through the 22nd.
Okay. So if we do every other weekend starting this weekend, then that would work for the 18th as well. So let's do she gets this, I guess 6 to 10, 2 times a week for a total of 3 to 5 hours. So she still gets that, but it can be unsupervised. And then every other weekend. So starting with this weekend, and let's just have that weekend, until school starts. Let's have that weekend start Friday morning. And then obviously I don't have Dad's schedule in front of me, so I know that he's a shift worker. So hopefully the parties or council can work together to get that worked out, so it doesn't fall in any weird times for either party. And then let's have that schedule in place. And do you think, I guess, Miss Bliss, if he starts working on that evaluation, we keep that in place until maybe August 29th? Do we think we could get an evaluation back by then with collateral input? We can try.
I mean, obviously that's my hope. Yes.
Okay.
I can guarantee he'll have that scheduled by then. Hopefully at that point he'll have, and I'll make sure to provide Ms. Rush all of the updates as I get them as well. My instructions to him will be to schedule that today after we get off the call today, because I do see that he's present on Zoom. As soon as he gets me a date in which he is scheduled to have that appointment, I'll provide that to Ms. Rush so that her client can obviously have the ability to provide the collateral input, and obviously by the graces of whoever the evaluator is getting that done, hopefully we get that back by the 29th, but if not, then maybe we can have an idea as to a timeline, at least at that point.
And I'm fine with parties moving that date forward or backwards by agreement, if there's as long as that's communicated amongst the parties, and with the hope of expanding Miss Sweet's visitation pending the outcome of that. but frankly, with there being no issues with Mr. Emter's custody of the child for the vast majority of the last 8-9 months, to me, we're looking at more of a 50-50 plan moving forward, assuming there's no issues in that evaluation. So I'm obviously it's a step up. So Ms. Sweet probably isn't getting exactly what she wants today, but my hope would be that her that we're expanding and that we'll continue to expand the amount of time that Ms. Sweet has, and that both parties will be able to maintain with the child.
Well, and Your Honor, I guess just one question, because I think my client might have this question for me. So, I mean, you've read the GAL report, obviously, and the findings, and I mean, the people basically found that dad was not telling the truth when this case started. But are you indicating that because that really is not directly tied to his parenting, that you're kind of compartmentalizing what they said about dad versus his parenting? Or
I'm not going to say that. No, I'm going to say that I don't see. At the beginning of a case, I think a lot of accusations, a lot of people are heated, a lot of things happen. Frankly, the concerns that were brought up about Miss Sweet were clearly more concerning to the court than those of Mr. Emter. Are both parties without some responsibility and blame in this case? Absolutely not. And I'm hoping that we can move forward in a positive manner where both parties are able to have as much time as possible with this child. There's been no concerns with parenting on behalf of Mr. Emter. So I frankly don't think, based on the GAL report, that I'm willing to just say, nope, Mr. You're out. Here comes Mrs. back in. I don't find a basis for that. So.
Okay. And would you like us to draft a whole new parenting plan pending end of August, or just do an interim order? What's your preference?
I think an interim order, since it's likely, I'm not denying your client's request at this point. I just want a little bit more information, and I'm expanding her visitation. So an interim, and then once we get the DV evaluation back, that's when I'd potentially be looking at entering a new temporary
parenting plan. Okay.
All right.
And do you wish for me to stay on this, or would you like to dismiss me at this point?
Does either, I guess I ask you to stay on. You've requested the DV, so if that changes any opinion, once that's received, and the collateral input can potentially include you as well. So I think it should be Ms. Sweet and the GAL are authorized normally for collateral input. So I'd like you to stay on at least until we have that back. And then if there's any supplemental information you want to provide to the parties in the court, that would be great. And if not, that's fine as well. And then you're free to go, subject to any recall for testimony at trial if we get to that point.
Okay, thank you.
All right. So I'm sorry, I think I said a hopeful date of August 29th at 1 p.m. If that can be moved up, that'd be wonderful. If it needs to be struck and reset upon agreement of the parties, I'm fine with that.
Okay, and I'll get an order done and over to Ms. Bliss, and then we can use that date for entry in such cases we can't get an order done, but I suspect we will, if that's fine with Your Honor.
That works. I trust you both. Okay. All right. Okay, good luck.
All right, thank you, Your Honor.
Thank you.
Thank you, Your Honor.
Thank you. I believe that is the last matter.